Supreme Court now is ordering CNN to respond to essentially our suit saying, at this point, what considered a public figure when you have been told lies continually over and over again, proven lies.
Remember what this case is about. Alan Dershowitz, who's a Democrat, was one of our defense attorneys at the impeachment trial, the first one of Donald Trump. He was one of my co-counsels. We brought him into the case. He handled specific constitutional issues, very specific, saying that there was no grounds to impeach the sitting president of the United States during that proceeding. He got a lot of flack from the left on that, as you can imagine. But what happened was CNN went on air as soon as he was done with his first presentation, misstated his main thesis of the case. In fact, they said he said the opposite. So under the New York Times versus Sullivan, when you're dealing with a public figure, they basically had, as you said, Logan, blanket immunity. They could say whatever they want. The standard that we would have to reach to prove defamation is very, very high. But what's interesting here is one of the judges at the 11th Circuit Court of Appeals said that the only thing standing in the way from Professor Dershowitz and justice is this old 1964 Supreme Court case, which actually talked about public officials, like government officials. It didn't even really talk about public figures.
When we filed, CNN waived their right to reply to our application. So for the court, the cert petition for the court to take the case. That was because they were hoping the court would just take ours and then say, okay, we're not, they take it to conference just with ours, and that means likely not hear the case.
Right, throw it out.
The Supreme Court yesterday gave CNN a deadline to reply. So even though they waived their reply, they are now being asked by the Supreme Court to reply to our brief, which means it's not 100% the Supreme Court will take the case, but this is exactly what CNN did not want to happen. So their strategy was, we're not even going to respond. We'll let the court just handle this, and the court has now handled it by saying, we want your response within a month.
Yeah, this is a good moment.
And when you looked at the decisions by the lower courts that got it up to this level, many of them ruled in favor with CNN because of the New York Times v. Sullivan reasoning, even with judges at the appeals court level saying, under all standards, this is defamation. However, because of New York Times v. Sullivan, we cannot find that there was defamation here. So even that, the lower courts push it up to that Supreme Court question of, is the New York Times v. Sullivan standard even still relevant in its form as it is? And that's exactly why we're going to the Supreme Court with it.
Generally, when the strategy of not responding, which is what they initially did, was also to kind of get a temperature read of, is the court interested in this or not? For instance, we were set for a conference to vote on certiorari on Thursday, tomorrow. They were to vote tomorrow on the case, whether they were going to hear it or not. But what happened here was CNN was hoping that there would be no order. It would go to conference and be denied. But instead, a number of justices of the Supreme Court said, no, we want to hear what CNN has to say, and then we'll decide if we take it. So it's going to delay it until probably April, maybe even May. We'll file another round of briefs in this. But this is a really significant case for accountability in the media and long overdue.
When you go back to 1964, when this case came out, Dad, and you look now to 2026, who is a public figure has changed so much. I mean, it's not just a handful of people who make it on 3 TV channels or are well known in local news or newspapers, and it's there's so many citizen journalists and podcasts and people in the media and the Netflix, all these different ways. It's not the same kind of control, so that it makes it nearly impossible for anyone who's got any kind of name out there and following to bring a defamation case where someone has absolutely either lied about you or just recklessly disregarded. That means you don't care if it's a lie or not, to show that actual malice standard. But you, the plaintiff, it's also a bizarre move in court. have to prove the intent of the defendant in this case. I mean, you have to show what was going on in their head or in their newsroom as they were putting the piece together. They don't have to defend it. You have to actually present it, which also makes it almost an impossible bar to overcome. So, and this is, I think, in the changing media landscape, the perfect time for the Supreme Court to look at this to say, this might not be the right standard anymore for 2026 and onward.
Well, I think, Jordan, that's exactly right. You had a dual burden here, which you don't have in any other kind of case. You had this dual burden where you had to meet the threshold of knowledge of falsity, and then the burden was on us to establish the issues rather than the defendant having to establish their defense. But look, the fact that the Supreme Court said we want to hear from you on this is a big development. It's a very positive development for justice here. Alan Dershowitz was wronged. We want to make it right. That's why we're stepping in and hold the media accountable. We get so many calls where people say we want to hold the media accountable. This is that case.
As the lower courts have acknowledged with Professor Dershowitz, they say he was defamed, but there's no action the court can take right now under the current case law from the Supreme Court under New York Times versus Sullivan because of the actual malice standard.
They created a false legal doctrine claiming it was the Dershowitz doctrine based off what they said that he said on the Senate floor in the well of the Senate by clipping out a portion of his presentation before the Senate, but leaving the qualifier out of it. So basically him giving a if this, then this scenario, they clipped part of it out and played that not just one time, but repeatedly over the course of many different broadcasts and called it the Dershowitz doctrine, which was in fact the opposite of what he was saying. So now when you think about a world that we live in now, say when New York Times v. Sullivan happened, you didn't have instant rewinds and broadcasts that were archived on places like cspan.org that you could go back and watch. It wasn't as readily available for the public to go fact check themselves if what they're saying is true. And maybe you could even give them the benefit of the doubt that they misheard it when they reported it. So, okay, I understand giving someone that doesn't have all the modern tools the ability that maybe they made a mistake in reporting, maybe they weren't very good at what they were trying to do, their job. You don't have those excuses anymore that a journalist was just incompetent because they can headlines. And when the news organization repeats it over and over and over again, they have the ability to get it right. And the public has the ability to view the source material and see that you are correct or wrong. So just in and of itself, the fact that the world has changed like that and what CNN did, this shouldn't apply. This should be something where you don't even have to read their mind. They defamed the individual here because they could have proven themselves wrong very easily, and they didn't do it. So once again, that's why something like New York Times v. Sullivan needs to be reassessed. In this current day and age, it needs to be reassessed. And that's exactly what we are doing at the Supreme Court with this cert petition. And now that the court, obviously, when it was going to conference, thought, this is serious enough. We need to hear what CNN has to say.